Judgment in the matter of Lachaux versus Independent Print Limited and another.
Lord Sumption will explain the decision of the court.
Mr. Bruno Lachaux is a French aerospace engineer who at the relevant time lived in the United Arab Emirates. This appeal arises out of 3 libel actions which he has brought in England against various newspapers, print and online. The 3 actions have a common background. In April 2011, Mr. Lachaux began divorce proceedings in the courts of the United Arab Emirates against his British wife, Afsana. There was a dispute between them about custody of their young son, Louis. In the course of that dispute, Afsana went into hiding with Louis, and in her absence, Mr. Lachaux obtained a custody order. He subsequently initiated a prosecution against her for child abduction, and finally physically recovered possession of the child. These painful events gave rise to a flurry of news articles in the British press, which were highly critical of Mr. Lachaux. Mr. Justice Eadie held that the meaning of the articles was that Mr. Lachaux had been violent and abusive towards Afsana, had made use of the UAE courts to deprive her of custody and contact with her son, and had callously taken Louis away from her and then falsely accused her of abducting him. The Defamation Act 2013 makes a number of changes to the law of libel. One of the most important of these changes is to introduce a threshold of seriousness before a statement can be regarded as defamatory. The statement must have caused or be likely to cause serious harm. The issue on this appeal is what constitutes serious harm. Mr. Lachaux says that it is necessary to determine whether the harm to his reputation was sufficiently serious by looking at the meaning of the words and their inherent tendency to cause harm, but not at their actual impact. This, he says, is because the law presumes damage in the case of defamatory written statements. The newspapers, on the other hand, say that the effect of the Act of 2013 is to introduce a threshold of actual harm, which has to be proved either by evidence or possibly in some cases by obvious inference. The common law presumption, they say, has nothing to do with this new statutory requirement. The judge, Mr. Justice Warby, substantially accepted the newspaper's case on the law, but having examined the evidence, he found that there was actual harm and that it was serious. So he found against the newspapers on their own legal test. The Court of Appeal took a different view of the law, which was closer to that advanced by Mr. Lachaux, but they agreed with the judge about the facts. So Mr. Lachaux succeeded before the Court of Appeal as well. The Supreme Court unanimously dismisses the appeal. The first and most important question is what is the meaning of serious harm? In this court's view, the meaning of that expression does not depend on any legal presumption based on the inherent tendency of the words. The law divides defamatory statements into 2 categories: statements which are actionable in themselves, where damage to the claimant's reputation is presumed and does not have to be proved, and statements which are actionable only if there has been some pecuniary loss which must be proved. Libels, that is to say, written or broadcast statements with an inherent tendency to damage the claimant's reputation, are actionable in themselves. The same is true of certain kinds of slander, i.e. oral statement. All other slanders are actionable only on proof of special damage. The effect of the new Act is to introduce an additional condition that must be satisfied before a statement, whether written or oral, can be regarded as defamatory. In this court's judgment, the language of the provision clearly shows that Parliament intended this threshold to depend on the actual facts and not on any presumption of the common law. The test is stated in the Act to be whether the statement has caused or is likely to cause serious harm. The reference to a statement which has caused serious harm points to some historic harm which can be shown actually to have occurred. That necessarily depends on what impact it has had on readers. In that context, the reference to a statement which is likely to cause serious harm must have a corresponding meaning, but referable to its future impact. Not only is this the natural meaning of the words, the next provision of the Act confirms this. The next provision says that in the case of a body trading for profit, serious harm must involve some financial loss. That can only mean harm which can be measured by the actual financial impact of the publication. If, as Mr. Lachaux contends, the new threshold only means that the claimant must show that the statement was the kind of statement that could be expected to cause serious harm, then a provision of the new Act, which was clearly introduced so as to achieve a significant change in the interests of freedom of expression, has achieved almost nothing. So the Supreme Court, like Mr. Justice Warby, accepts the newspaper's interpretation of the Act. But Mr. Lachaux still succeeds on the appeal because Mr. Justice Warby and the Court of Appeal agreed that the harm was in fact serious in this case. This court will not normally interfere with findings of fact made by both courts below unless it can be shown that it was vitiated by some error of law or mistake of principle. This court finds no error of law or mistake of principle in the judge's assessment of the facts. Accordingly, the present appeal must fail.